In a case that tests the fine line between a school's curriculum choices and a family's religious beliefs, the Supreme Court has stepped in on behalf of parents in Montgomery County, Maryland. At issue is a policy that added LGBTQ inclusive storybooks to elementary classrooms without telling parents or letting them opt out. The justices said that forcing these lessons on students without notice steps on parents' rights to guide their children's faith and values. By granting a preliminary injunction, the court put the board on pause. Schools must now alert families ahead of time and honor opt-out requests while the case moves forward. This decision doesn't decide the whole fight yet, but it shifts the power back toward parents for now. Stay tuned after the break to hear what comes next and what it could mean for classrooms across the country. Nine Robes uses non-partisan, everyday language to focus on the facts of what the Supreme Court is saying. Here, you'll find clear, concise summaries of every Supreme Court opinion, stripped of legalese and clickbait headlines. Each post breaks down the facts, explains the court's reasoning, and highlights the crucial details that often go unnoticed. It's not just about what the court decided. It's about why those decisions matter, to give you a deeper understanding of the cases that define our nation's legal landscape. These summaries are generated by AI. Be careful and consult reputable sources when in doubt. During the 2022-23 school year, the Montgomery County Board of Education introduced 5 LGBTQ inclusive storybooks into its K-5 English curriculum. These books feature narratives of same-sex marriage, gender transition, and LGBTQ characters, e.g. Prince and Knight, Uncle Bobby's Wedding, Born Ready, Intersection Allies, Love Violet. Parents from diverse religious backgrounds initially were allowed to opt their children out of lessons using the books. In March 2023, the board rescinded that opt-out policy, citing administrative disruption and potential stigma for LGBTQ students. A group of parents and an associational plaintiff sued in federal court, arguing that withholding opt-outs and mandating use of the books substantially interfered with their right to direct their children's religious upbringing under the Free Exercise Clause. They sought a preliminary injunction to restore advance notice and opt-out rights. The District Court and Fourth Circuit denied relief, treating the Wisconsin v. Yoder case as unique and concluding that mere exposure to ideologically objectionable material doesn't coerce students to abandon parental religious teachings. The Supreme Court agreed to hear the case to resolve whether the board's no opt-out policy unconstitutionally burdens parents' free exercise rights. Justice Alito, writing for a 6-3 majority, Roberts, Thomas, Gorsuch, Kavanaugh, Barrett, reversed the lower courts. The court held that parents possess a fundamental right to direct the religious upbringing of their children, which the Free Exercise Clause protects in both public and private school contexts. Under previous Supreme Court precedent, policies that substantially interfere with parental religious instruction or place children in an environment hostile to their faith and exert a pressure to conform trigger strict scrutiny even if facially neutral. Here, the board's curricular mandate and denial of opt-outs force parents to choose between public schooling and their religious convictions. The challenge storybooks present a normative viewpoint on same-sex marriage and gender that directly conflicts with petitioners' sincerely held beliefs and are taught in a manner fostering classroom discussion in which students who disagree may be labeled hurtful. The board's asserted interests, preserving classroom continuity and protecting LGBTQ students from isolation, are undermined by district policies allowing opt-outs from other discrete units and extensive parallel programming for special needs and emergent English learners. The board's policy is not narrowly tailored to a compelling interest. Because withholding opt-outs imposes an irreparable burden on religious exercise, a preliminary injunction reinstating advance notice and opt-out rights pending full adjudication is warranted. Justice Thomas concurred. He agreed that the board's policy fails strict scrutiny, but would ground the analysis in historical tradition. He argued that courts should identify whether public schooling historically included mandated instruction on the challenged subjects. Thomas would interpret Wisconsin v. Yoder to require a history and tradition inquiry, and faulted Montgomery County for lacking any long-standing practice of teaching LGBTQ themes in early grades. Justice Sotomayor, joined by Justices Kagan and Jackson, dissented. She emphasized that mere exposure to ideas incongruent with parental faith does not amount to coercion or compulsion prohibited by the Free Exercise Clause. The dissent argued that the board's curriculum and related teacher guidance were aimed at fostering mutual respect and inclusion, not at indoctrinating students or forcing them to reject parental teachings. She warned that the majority's unbounded threat test would saddle public schools with unworkable advance notice and opt-out obligations for any curricular content potentially contrary to parents' religious views, risk persistent classroom disruption, and prompt self-censorship of public school curricula, undermining the school's role as the most pervasive means for promoting our common destiny. The key question under the Free Exercise Clause is whether government action coerces an individual to violate or abandon religious beliefs, not simply whether it exposes students to objectionable ideas. Under precedent, neutral, generally applicable policies that impose only incidental burdens on religious exercise survive unless they impose a substantial interference with the religious upbringing of children. When such a burden arises, strict scrutiny applies regardless of neutrality. To pass that test, the government must show its policy advances interests of the highest order and is narrowly tailored. Here, the court found that the board's no opt-out rule, combined with the normative messaging and teacher guidance in the LGBTQ+ inclusive storybooks, posed a very real threat to parents' right to direct their children's religious development, and that the board's asserted interests were not compellingly served by a blanket ban on religious opt-outs. The decision reinforces the delicate balance between respecting parental religious liberty and ensuring an open, pluralistic public education environment. Find us online at 9robes.ai. That's the number, 9robes.ai. Like and share this podcast with friends that like to be informed. 9 Robes provides AI summaries of U.S. Supreme Court cases. AI makes mistakes. People make mistakes too. We genuinely do our best to provide you with the most accurate summaries, but our best sometimes includes errors.